Good evening, everyone, and welcome to this webinar organized by the School of International Arbitration at Queen Mary University of London. My name is Dr. Rémi Gerbet. I'm one of the academics at the School of International Arbitration at Queen Mary, and I'm also a partner at the law firm Hughes, Hubbard & Reed in Washington, D.C. Now, each year, the School of International Arbitration at Queen Mary University organizes about half a dozen seminars like this one, where we invite external speakers, friends and supporters of the school to come and discuss topical issues in the field of international arbitration. The purpose of this series of webinars is twofold. First, to give our students an opportunity to hear different perspectives on the issues that they study during the LLM program. And second, to nurture the deep relationships that the School of International Arbitration has built with the wider arbitration community since the 1980s by offering a free and open forum where practitioners, scholars, and students can come together and continue to learn about international arbitration. The topic of today's webinar is Arbitration Through the Ages, a discussion on the evolution of international arbitration. And in today's webinar, we're going to explore the evolution of international arbitration, both from sociological and historical standpoints. And to take us through these topics, we're incredibly lucky to have two speakers in Dr. Florian Grisel and Dr. Mikael Schinazi. Florian and Mikael, good evening, and thank you both for joining us.
Thank you. So hi, everyone. It's a great pleasure to be here today along with Professor Grisel, and many thanks to Rémi Gerbet for organizing this event and to the Queen Mary Center for Commercial Law Studies for hosting this webinar. Florian and I will speak for about 15 minutes each, and we will then have a bit of time for questions with Rémi, including that very important question, why should we care? So to provide a quick overview for today's presentation, we've divided this presentation into two parts, each dealing with our current interests. So I'll be discussing historical approaches, and then Florian will discuss sociological approaches. With respect to historical approaches, since this webinar is being hosted by Queen Mary, I thought I'd say a few words about a very interesting type of arbitration that took place in England in the 19th century and had an impact on the modern practice of international arbitration. And I will then delve into the origins of the ICC, the International Chamber of Commerce, and its Court of Arbitration. And finally, I'll discuss the development of the ICC arbitration system. Okay, so starting with arbitration in 19th century England, I want to briefly discuss arbitration within local trade associations. And while this may seem like a niche topic, it seems to me that this form of arbitration, which was very important at the time, helped develop or strengthen key ideas and principles that proved important for the modern international arbitration regime. As a lot of you will know, commercial arbitration was widely practiced in Europe throughout the 19th century and beyond. And during the Industrial Revolution, England was the world dominant economic power and the focal point for buyers and sellers in the grain market, as well as in other commodity markets. Here you have a chart showing the organization and the operation of the London and Liverpool commodity markets from the 1820s onward. And it lists some of the major trade associations existing at the time in the grain, sugar, coffee, rubber trades, etc. And crucially, various arbitration bodies were created in local trade associations. You'll see very shortly that ICC arbitration was very similar to arbitration in those early commodity markets. Of all the trade associations, the London Corn Trade Association, the LCTA, came to play a particularly important role, arguably acting as the benchmark model that was emulated by other institutions in the following decades. The LCTA was founded in 1878, and it sought to facilitate the grain trade by setting quality standards, standardizing shipping documents for major exporting nations, and clarifying arbitration procedures. Now, many features of LCTA arbitration made the LCTA quite remarkable indeed. It had a unique international reach, fairly low operating costs, and a very efficient arbitration system whereby arbitrators would render a decision quickly based on deep technical expertise. In particular, the LCTA relied heavily on standard contracts, such as the ones you can see on the screen here. And crucially, these standard contracts contained arbitration clauses providing that any disputes arising out of the contract would be finally settled under the LCTA rules. Now, this helps explain why parties engaged in global trade had little choice but to submit their disputes to the arbitration mechanisms of the LCTA and other trade associations. And as a result of this, Great Britain secured its place as a major provider of legal services through arbitration. Now, in the early 20th century, European traders became increasingly reluctant to use the English commodity market institutions. New institutions were established in continental European cities, and after the First World War, a new arbitration system emerged to settle disputes between merchants. This was the ICC arbitration system, which did not replace the old LCTA model, but it was different in that it was less grounded in England and much more international in scope and nature. There are three main dates that explain the birth of the ICC. The first date is 1919. That year, business leaders in the allied countries of Great Britain, France, Belgium, Italy, and the US met at an international trade conference in Atlantic City, New Jersey. The goal of the conference was to assess the material needs of the four principal allied nations in the aftermath of World War I. And this was a very large conference. It was attended by 4,000 people, and it was described by one member as nothing less than the most important trade meeting in history. The ICC's founders acted on their conviction that the private sector was best qualified to set global standards for business. They called themselves the Merchants of Peace, which is also the title of one of the very first studies of the ICC by George Ridgway, Merchants of Peace, published in 1938. And this reflects the early inspiration to foster peace and security through trade. At the conference, a committee was formed to discuss plans for the creation of an international chamber of commerce, and it was decided that the new organization would be located in Paris. The second important date is June 1920, which is when the ICC was officially constituted at a public meeting at the Sorbonne in Paris, in the presence of senior politicians. And the key figure here is a man few people have heard about, Étienne Clémentel. He was the very first president of the ICC and of the ICC Court of Arbitration. Just to provide a bit of background into his very interesting life, Clémentel served as a member of the French National Assembly and as a senator. And he also held various government portfolios as Minister of France's colonies, agriculture, finance, commerce, and industry. He was very much involved in the creation of the ICC. And finally, he was also an art collector and patron. His friends included Rodin, the famous sculptor. And here on the right, you can see a sculpture by Rodin of Clémentel, and it's a bust of Clémentel that is still on display in the ICC's current headquarters in Paris. So a very interesting life, and this man became incredibly interested in international arbitration and was the first founding president of the ICC and of the Court of Arbitration. Now, the third date is the inauguration of the ICC Court of Arbitration, and this was in 1923. So you see that the ICC was created in 1920, and then very early on, it became interested in international arbitration. In 1923, the Court of Arbitration is inaugurated. And this inauguration took place at the Tribunal de Commerce, the Tribunal of Commerce in Paris. And I think it's very significant that this inaugural meeting took place at the commercial court, as if to show that despite being a private initiative, the ICC and the broader arbitration community would endeavor to work hand in hand with the domestic courts. Here on the right, you can see the successive premises of the ICC in Paris. Finally, I want to discuss a few selected topics on ICC history. And this is just to give you a flavor of what can be done with the wealth of historical materials in the ICC's archives, to which both Florian and I had access. I'll say a few words about changing trends and case characteristics, about the evolution of the ICC's rules of arbitration, about the scrutiny of draft awards, and then finally the ICC's role in drafting the New York Convention. And this is only meant to provide an illustration. A lot more could be said about all this. So what was ICC arbitration like in the early years and decades of its existence? I've had access to more than 130 arbitral awards from the 1920s onward, and they tell us various things about the evolution of ICC arbitration. Initially, at least, the awards were very short. They were only a few pages long. The arbitrators were mostly non-jurists. They were engineers, members of local chambers of commerce, merchants, members of the tobacco journal, industrialists. And these people had to adjudicate disputes that were about mostly quality disputes. And you see a list on the left of the types of disputes submitted to ICC arbitration in the 1920s. Now, in these cases, the arbitrator would manually examine the goods. And this is a quote from an award rendered in a case where the arbitrator requested a sample of the goods. This is very similar to what we saw earlier about the commodity market arbitration in England in the 19th century. So you can see this original inspiration in the early years of the ICC. In the 1930s, the subject matter of disputes submitted to ICC arbitration is already very different. The cases are about the publication of articles in a sport magazine, an exclusive license to use a water softening agent, agency agreements, licensing agreements, right? So you can see here that these cases involved far more complex legal and factual issues than the cases in the 1920s. In a way, this shows that ICC arbitration developed rather quickly from an informal type of justice to a more robust judicial system. The second topic I'd like to briefly discuss is the evolution of the ICC rules of arbitration. Here on the screen, you can see the very first arbitration rules, the 1922 rules. And these rules were formerly known as the rules of procedure for the conciliation and good offices of the ICC. They were divided into three sections, with one section dealing with conciliation and then two sections dealing with arbitration. Interestingly, conciliation came first, and it was by far the most important of the two services. And it seems to me that there is a push today to make mediation an even stronger component of dispute resolution. So query whether we might be going back to this original inspiration to some extent. There have been 14 successive versions of the ICC rules from the creation of the ICC to the present day. The last version of the rules was in 2021. And what this shows is that the ICC has been continuously adjusting to meet the demands of its users. Another area where the ICC played a pioneering role is in scrutinizing arbitral awards. The ICC's scrutiny process is an example of a rule that was developed over time to improve the efficiency of the arbitration system. The 1922 arbitration rules were silent on the matter, but the commentary to the 1923 rules clearly stated that draft awards should be scrutinized. And you have the quote here on the top right of the screen. Now, you have to remember that arbitrators in the 1920s and 30s were not professional lawyers or full-time arbitrators. The quality of awards ranged widely, so it was useful to have the court review the awards. Initially, the court's scrutiny of draft awards extended only to the form, not the substance of awards. And here you have a second excerpt from the 1923 commentary that says exactly that. However, by the 1930s, the principle of scrutiny of draft awards had become firmly established as part of the practice of the ICC court. And today it's a cornerstone of the ICC arbitration system. And then finally, I just want to say a few words about the ICC's key role in drafting the New York Convention. What few people know is that in March 1953, the ICC adopted a preliminary draft convention on the enforcement of international arbitral awards. And the ICC draft convention adopted a very modern approach. It got rid of what's known as the double exequatur requirement of the Geneva Convention, which had been the key instrument prior to the New York Convention. And it also made fewer references to national law, giving increased importance to the party's intention and to the arbitral process as being detached from national laws. And crucially, the final text of the New York Convention is very similar to the ICC draft convention. So again, what this shows is that the ICC has very much been at the forefront of legal developments. Now, for those of you who wish to explore these topics further, you can find a lot more about the history and the evolution of international arbitration in those two books. The book on the left, which was co-written by Florian and Professor Alex Dunsuit, and then my book on the right. So thank you very much, and I'll now pass the floor to Professor Grisel.
Thank you very much, Michael. Let me share my screen very quickly here. Hoping that everyone can see now. Thank you so much. So I'd like to start by thanking Queen Mary and Rémi Gerbet for the very kind invitation. I'm very grateful for it, and I'm also very thankful to be able to do this presentation with my friend Michael Schinazi. What I'll do in the next 15 to 20 minutes is to take a kind of sociological stance on some of the material presented by Michael earlier today. And basically, I will present my argument in 4 steps. First, I will describe a dominating argument in the literature on the sociology of arbitration, casting international commercial arbitration, or ICA, as I call it, as a competitive field. As a second step, I will look into the roots of this argument into the sociology of Pierre Bourdieu. Then I will present an alternative argument, which I will sketch out as interpreting ICA as a cooperative field, and then I will end with a few comments on social reproduction in ICA. So let me start with the first idea, which is drawn from the literature on the sociology of ICA, a literature which is dominated still today by a book by Yves Dozalin and Brian Garth, published at the University of Chicago Press in 1996. Dealing in Virtue. So this book is famously based on a series of hundreds of interviews with the practitioners of international arbitration in the 1980s. And one of its core studies is the ICC, which explains why I will focus today mostly on the ICC, and perhaps that's something we can discuss during the Q&As. In their book, Dozale and Garth understand and analyze what they believe is a key evolution in international commercial arbitration in the 1980s. And this key evolution is basically a competition between two groups of lawyers. One group of lawyers composed of leading continental academics, as they call them, or grand old men. These are, broadly speaking, law professors based in continental Europe, rooted in the civil law tradition, and whose authority, to borrow from Max Weber's terminology, is charismatic. The parties listen to them because they are these grand old men that have this knowledge drawn from their expertise in academia. The second group of contenders of lawyers are symmetrically opposed. They are practitioners, litigators based in Anglo-American law firms with expertise rooted in the common law tradition. And the nature of their legitimacy and authority is quite different. They are legitimate because they have a kind of technical expertise, what Max Weber would call a rational legal authority. They are legitimate because they know the law and they know the techniques of litigation which they use in international commercial arbitration. So in a word, Dozale and Garth understand international commercial arbitration. That's the title of Figure 1, which is reproduced from Chapter 3 of the Dealing in Virtue, as a field of structured opposition. And this opposition is the one between the grand old men and the young technocrats, the two groups of lawyers that I just described. This conflict was, according to Dozale and Garth, solved by the success or the ability of the young technocrats, the litigators, to prevail and to shape international commercial arbitration in their own image, which is a highly judicialized system, more legal, more technical, and less equitable in some ways. Where does this notion of a field of structured opposition come from? That is the second step, basically, in my argument today. It comes from Pierre Bourdieu's field theory. And of course, most of you already know who Pierre Bourdieu is. He's this famous French sociologist who had enormous influence on the social sciences. And his theory of the social world is based on three discrete notions. The notion of social field, the notion of habitus, which is a word he created for that purpose, and the notion of symbolic capital and violence. What matters for our purposes here is the first notion of social field. This notion of social field is characterized by, according to Bourdieu, by the opposition between various groups, and the fact that the groups that achieve to dominate these struggles, this conflict, is the one that shapes the social field in its entirety. So to give a concrete example of what it means in the case of international arbitration, let me read this sentence, which is the foreword by Pierre Bourdieu in Dealing in Virtue. I quote, "Conflicts between jurists of different countries seeking to impose their judicial forms or their modes of producing law contribute to the progressive and unfinished unification of the global legal field and the global market of legal expertise. The international is constructed largely from the competition among national approaches," end of quote. And the underlying argument by Bourdieu is that this competition among national approaches is won by one of these national approaches, typically the Anglo-American approach, the common law systems, the litigation techniques inherited from Anglo-American law firms. So this is, of course, a very important argument. Dealing in virtue was extremely successful from 1996 onwards when it was published. But interestingly enough, the book raised some criticisms from the outset. And these criticisms emanated from practitioners of international arbitration. So here I've selected two citations from two practitioners of international arbitration who wrote reviews of dealing in virtue in 1997. One of those practitioners is Eric Schwartz, who was at the time the Secretary General of the ICC. And here is what Schwartz wrote about dealing in virtue. There is little basis, in my view, for the author's contention that conflict between an aging cadre of notables, i.e. grand old men, and a younger generation of technocrats has helped to shape the modern development of international commercial arbitration. Many of those prominent in international arbitration are at the same time academics and practitioners, which makes it even more difficult to speak of cleavage between the two. So it's quite interesting to see that there is some pushback. There was some pushback from the arbitration community on this insistence on a conflict having shaped the field of international commercial arbitration. Another quote from John Beechey, who was at Clifford Chance for many years before becoming the chairman of the ICC International Court of Arbitration, basically captures the same idea. And I will not read through this citation, but Beechey is basically criticizing dealing in virtue for the same reason, for overemphasizing the existence of conflicts, when in fact practitioners of international arbitration have, according to them, more complex profiles. Now, I'd like to introduce my own argument, and this is a tentative argument, perhaps more a hypothesis, based on preliminary work in the archives of the ICC, and also the issues of the Journal of the ICC World Trade. And from these sources, I was able to identify 644 cases between 1922 and 1973. And in these 644 cases, I was able to identify over 1,000 appointments of arbitrators in these cases. So when I look at these appointments and I classify them by decades, so there are 5 decades between 1922 and 1973, one can see a wide diversity of professional groups involved in arbitration at the ICC. So you see arbitrators who are members of trade federations, you see public officials, you see businessmen and corporate executives, you see judges, attorneys, professors, engineers, and experts. So what you see are not only jurists, as Mikael pointed out very clearly earlier today, but also and predominantly at the beginnings, a non-jurist. But what you also see is that throughout these decades, and I would like to draw your attention to the red arrow. You can see this red arrow, which is growing across time. This red arrow represents the proportion of jurists appointed as arbitrators across these 5 decades. And you see that this arrow is growing. This is linked, according to me, to what one can call the judicialization of international arbitration, the fact that it has been legalized more and more technical across time. And that's also something that Mikael pointed out earlier today. But of course, when you look at this data through the claims made by Yves Dezalènes and Brian Garth, you have some difficulties to identify this class of grand old men in the period that is immediately preceding this key turning point that they identified in the 1980s. What you see in the last decade that I was able to investigate, the decade from 1963 and 1972, is the domination of attorneys, lawyers, barristers, appointed as arbitrators. You see a respectable proportion of professors, 150 appointments, but still it is a minority. So these figures tell us something about the sociological picture of appointments at that time, but we can look at this data from a different angle. So what I've done is to gather data concerning what I call the leading ICC arbitrators during this time period. And I adopt maybe a simplistic measure of this leadership. I simply considered individuals who gathered more appointments as arbitrators, as the leaders of that field. And you see a list of 10 names right in front of you. Those 10 names are arbitrators who were appointed between 11 times and 28 times between 1922 and 1973. So what we can see are some patterns, and some of these patterns are not surprising, and there is at least one pattern that is more surprising. First of all, these are all men, okay? And this is not really surprising. This is problematic in many ways, but this is not very surprising when we consider the time period when this data was taken. We see men from Western Europe and more specifically continental Europe, which seems consistent with Yves de Zalen-Brand-Garth's claim concerning these continental lawyers grounded in civil law jurisdictions. But there are two dimensions that do not fit their sociological interpretation. One are the professions of these individuals. You see a wide variety of profiles, in fact. You see people who are attorneys, you see people who are, you see an international civil servant, you see a judge, you see, and you only see two professors. You only see two of these people who would have the profile of grand old men, according to de Zalen-Garth, these continental academics with charismatic authority drawn from their academic chair. So that's one distinction that is quite important to notice. There is another distinction which is less visible, but no less pertinent, according to me. And that is the origins and the life trajectory of most of these people. And I'm talking here of the 5 individuals whose name is highlighted in yellow. For a very long time, I couldn't see that pattern on this list. It took me several months to see it. And what I identified as a key sociological feature is the fact that these individuals highlighted in yellow were all migrants. They were all people who gained legal training in one jurisdiction, had to escape that jurisdiction, usually for reasons of religious persecution. And of course, that's quite obvious considering the history of Europe at that period, during this period of time, and then gained the knowledge of another legal system, another language. But very often they were not leaders in the jurisdiction where they landed, so to speak. So I'm not going to go through each of these individuals. I will simply say a word about one of them who was cast as an archetypical grand old man by Yves de Zalen-Brand-Garth. And this man is Berthold Goldman, the second name in yellow in the table. Berthold Goldman was, on the face of his profile, an extremely prominent individual, someone you could consider to be a grand old man. President of the University of Paris, a very famous professor in France, a pioneer of EU law, but also of competition law, and of course of international arbitration law. But when you look more closely at his profile, Goldman was a refugee. He was a migrant from Romania who studied very hard to be able to climb the ladders of French academia. And his profile is quite unusual in French legal academia. He became a professor because of his merit, but he could not shake off so easily his origins and also his religion. He was Jewish and suffered quite significantly from xenophobia during and anti-Semitism during his career. So the argument I make is that those people were not people who had elite status in their system of origin. There were people who were actually more marginalized from the perspective of their systems, but they had quite a unique capacity, and that capacity was to connect different systems with which they were acquainted, but in which they were not central. So they acted as intermediaries between those systems. So if you look, for instance, at the graph in front of you, at the drawing, you see individual D. Individual D is, according to me, one of these pioneers of international arbitration, someone who is not situated at the center of network 1 and network 2, but someone who is quite unique in being able to connect both networks. So this is this position of intermediary that makes D unique and able to create a new system of dispute resolution. Very briefly, I'd like to say a word about social reproduction in international commercial arbitration and whether we can extend the value of this model or this hypothesis across time. And what I've done is to use data which is now a bit dated, but I believe the people who are listed on this table are still what we can consider to be leaders of international arbitration, with a few exceptions of those who sadly passed away. So this is a list that was established by Who's Who Legal in 2015 of the leading commercial arbitrators in the world. And again, you see some interesting patterns. You see that this list is made mostly of men. You have 2 women. This is an exception. You see that these people come mostly from Western Europe and North America, with a few exceptions, but mostly these are their nationalities. But what is mostly interesting in my eyes are 2 more identifying features. One is the fact that all of them are jurists, and that is a major difference. That is another sign of this judicialization that I was mentioning earlier today. All of them have had careers as solicitors, barristers, lawyers in their respective countries. Another interesting feature is the fact that they all have complex professional identities of people who operate in different professional groups. So they are all, or they have all had some experience as practicing litigators or attorneys, usually specialized in the field of international arbitration, but they also have some activities in academic circles. They publish routinely about international arbitration. They are positioned at the margins of different professional groups. And I think that's another interesting feature when we compare this group to the earlier generation of leading arbitrators who also showed this capacity to establish dialogue between different systems. So the argument I would make tentatively is the fact that there is this high level of social reproduction in international commercial arbitration today that we can only fully understand by looking at the past. And that allows me to circle back to the question raised by Remy earlier today. What is the use of all these kind of academic exercise on the sociology and the history of international commercial arbitration? Well, this is a good way to end by looking at the ways in which the sociological profile of those leaders, in my eyes, can only be understood by looking at the evolution, both sociological and historical, of the field of international commercial arbitration. If one simply looked at the profile of those people, I believe one would simply miss part of the story that makes it very very relevant and much more understandable for observers of international commercial arbitration. So thank you very much for your attention. This is one of the papers where I make those claims, and I am very thankful to all of you. Thank you. I will stop sharing now.
Thank you, Florian and Mikael, for these very interesting presentations. Before I go back to my question and ask it again to Mikael, one point that occurred to me is that also a big change that I think happened since the publication of Dealing in Virtue by Dezale and Garth is the fact that a new generation of arbitration practitioners has emerged, a generation of lawyers who have only known arbitration as their field of practice. And up until certainly the beginning of the 2000s, maybe even the mid-2000s, most senior international arbitration practitioners were often coming from a background of litigation, which of course would have equipped these lawyers with a certain knowledge or a certain expectation as to how an arbitration should be run, based on their understanding of domestic litigation. But things changed then with the emergence of this generation of people, like I think ourselves here, who have really spent their entire lives as looking at arbitration as a specialist area, basically, without having that pre-existing background in construction litigation or energy litigation, etc., etc. So I think that adds, a layer of complexity. So Mikael, I'm going to ask you the question I asked at the beginning. As far as you're concerned, and perhaps focusing more on history than sociology, why should it matter for us to understand the history of international arbitration?
Yeah, absolutely. With respect to the history of international arbitration, I think it's fair to say that the history of the field has not been fully explored or written. And two of the finest scholars of the history of arbitration, Johnny Vider and Derek Roebuck, both died in 2020, and their work provides truly fascinating insights into the history of arbitration. But there's still a lot more to do in terms of the research and the archives. And I think Florian mentioned Berthold Goldman, but there's also the life of Clive Schmidhoff, who lived at the same time as Goldman and was also very interested in some of the same concepts, like Lex Mercatoria. And so, there's all these fascinating figures to explore and to investigate. Now, with respect to your question, international arbitration, as we know, is the topic of much criticism today. And while some of the criticism is entirely justified, some of it, I think, is clearly unfounded. And a greater historical awareness of where international arbitration comes from and where it might be heading can go a long way in addressing some concerns that some people have about the arbitral process. So I think it's vital to explore and to share the history of international arbitration so as to make informed decisions about the field and to fully grasp what it was designed to achieve and to not achieve, right? So I think it's the history of arbitration is critical in that respect.
And I agree with you. And I just shared in the chat a link to a freebie, basically a freely accessible excerpt of your book on the 3 ages of arbitration, which I thought was very interesting because it lists in a very succinct fashion all of these arbitration scholars or practitioners who have written about the history of arbitration. They're not historians, at least for most of them, as far as I can see, but you've listed all of these people, including Johnny Vider, Roebuck, and others. So if you're interested in this, that's a great introduction, or at least so I thought. So moving on to another question on history, Mikael, in your book, you describe a back and forth between renewal and anxiety throughout the history of international arbitration. Can you tell us a bit more about these two concepts and what you mean by that?
Sure, yeah. So when I started exploring the archives for my book in France, in England, and in the US, I realized that the history of international arbitration could be divided into three broad phases or eras, which I call the three ages of international arbitration. And then I looked at this historical material again, and I thought, this is really interesting. It looks as if the history of arbitration keeps going back and forth between periods of intense activity or renewal. And this was followed by interruptions, by periods of doubt over the meaning of international arbitration and its position in the wider legal landscape. And so this is what I call the tension or the pendulum-like movement between moments of anxiety and moments of renewal. And I think this image of a pendulum movement is interesting for at least two reasons. The first reason is that many scholars working in legal history tend to describe the history of a legal phenomenon as a linear process going from point A to point B. And what I try to show is that the full picture is more complex, that there are many initiatives that were largely unsuccessful, many failed attempts. And the second reason why I think this is interesting is that we're very much seeing this oscillation even today. The forces of renewal and anxiety are still very much at play. And I would argue they shape the contemporary landscape of international arbitration today. And importantly, and I'll finish on this note, I'm not arguing that renewal or anxiety are necessarily good or bad, right? I'm trying to describe what I see in the historical record. And anxiety often has negative connotations, but it can also be beneficial in some situations, right? When it alerts us to danger or other key pitfalls. And so I think it's not necessarily good or bad. I'm just trying to understand what we're seeing in the historical record and what we're seeing today.
It's really interesting, and I think this notion of pendulum, the movement throughout history, seems to be very relevant today, as we see with the post-globalization era, with the renewal of nationalism, economic nationalism, etc., the criticism of ISDS for right and good and bad reasons, and how this basically impacts now the discourse on international commercial arbitration. I think we really see that pendulum again, perhaps going towards anxiety, if I'm not mistaken. So now, before I move to Florian, just a point, because we have a question, I think, in the chat about legal pluralism. So you've briefly discussed modern history of arbitration in France and England in your book. And of course, France and England are two important jurisdictions, but does it mean you took a Western European focus? And if so, was it on purpose? Can you speak to that a little bit?
Yeah, that's a great question. It's absolutely true that my book concentrates mostly on the European origins of international arbitration. And there are two main reasons for this choice. The first one is purely practical. France is where I chose to do my research and also where I had access to the archives of the ICC, along with Florian. Florian also did exhaustive research in the ICC's archives even before I explored these archives. So we had access to this wealth of new historical data. And this is why I chose to pursue my research on the history of arbitration in Europe. But I think my argument about the oscillation between anxiety and renewal holds true in other geographical contexts as well. That's my hypothesis. And then the second reason is that Europe has played a key role in the modern history of international arbitration. And so it's a very interesting history to explore. Now, we have to be very clear that the history of arbitration was not shaped exclusively in Europe. Arbitration has a very rich and varied history in many parts of the world. And I think that when reading about the history of international law, it's very important to note, as Arnulf Lorca wrote in a very good book entitled Mestizo International Law, that the international law would deem universal and Western is in fact heterogeneous and global, right? So it's a very important caveat to have in mind. And I can only hope that other scholars will build on European accounts like mine to write a more hybrid history of the discipline. And in fact, I've written a piece that's forthcoming about the global history of international arbitration. And I think, there's a whole avenue for future research in that field.
It's very interesting. In fact, a few weeks ago, I organized another webinar for the American Society of International Law on proto-arbitration or the use of arbitration and litigation in ancient civilizations, focusing on Greece, Rome, and Egypt. And one of the issues that we touched upon briefly was the jurisdictional competition between arbitration and courts, state courts, royal courts, and non-royal courts, and how this connected to periods of quote unquote nationalism, if we can use that term in a way that's not too anachronistic in these ancient civilizations. And I think some of these phenomena or tensions that we had between arbitration and the courts, between different types of courts, this jurisdictional competition is something that we see still today around the world. So there's certainly a universalist aspect to these tensions or these problems, at least. So Florian, now moving on to you. So in your own research, you insist on sociological continuities in the field of international arbitration. Could you explain to us a little bit more? And do you see room for change as opposed to continuity? You're on mute.
Of course, sorry. Always happens. Yeah, so absolutely. I mean, that's a great question. I mean, that's often something that sociologists are criticized for, which is to only see how things are maintained and how they are changed. So that is in fact what I try to highlight in this work and in this presentation, how there are some key sociological features across time when you look at this type of arbitration in this institution. I also show some evolutions, but these evolutions are very slow. I mean, this is what I described as the judicialization of arbitration. It is a very slow evolution, and it is not an evolution that is managed or that is triggered in some ways by institutions according to a kind of preset plan. This is the complex product of various forces that basically coincide and lead towards a certain outcome. So I do not deny at all the possibility for change in arbitration, but I simply would warn or try to highlight, whenever we see changes, the continuities that may exist beyond those apparent changes. So we can, for instance, look at the recent sociological changes concerning diversity in arbitration, which are quite recent and which are obvious and I think needed. I mean, that's absolutely without debate. But we can also see some continuities beyond these apparent changes. If we look, for instance, at the professions of those who are leading arbitration today, we can see continuities with the previous generation beyond the changes of professional groups with which they're affiliated. So what I'm simply saying is that changes take a huge amount of time, and whenever we see changes, we also need to look at continuities. Yeah.
And coming back on the point you were making incidentally about the fact that changes are not decided, that they are the product of complex factors. I thought one thing that was perhaps exaggerated or emphasized in Desailles and Garth was this notion of competition between these two groups, the Grendelman and the technocrats, when in fact often in my own anecdotal experience, the community simply responds to a practical need, and so as you said in your own research, and Mikael was also pointing to that in his presentation earlier, there's been an evolution of the types of cases that have gone to international arbitration, and in particular to ICC arbitration. And today we have disputes that are infinitely more complex than what was going to arbitration under the ICC rules 100 years ago, post-M&A disputes and things like that. And with that increased technical difficulty and also the increase in the value of the disputes and therefore the amount of money that parties are willing to put into their legal representation, you end up with more sophistication. You end up with rules that are more precise and certainly more judicialized. But that's just a product of it's just a result, I think, of the community grappling with problems as they arise.
It is the problem with the overemphasizing social actors as agents of change, and not only as people who are also on the receiving end of other changes. So they respond to changes in the ways they can. They do not always engineer those changes. It's a complex balance between the two. And I would absolutely agree with what you're saying. Yeah.
So a follow-up question, Florian. So your research has focused a lot on commercial arbitration, but can you expand it to expand your findings to investment treaty arbitration, which is a slightly different type of practice area?
And I would even go further. I would say that it's an entirely different animal, at least on the face of it. And at least if you look at investment treaty arbitration, I guess, if you look at state contracts, that's probably a little different. But you would expect to see very different people occupying leading positions in the field of investment arbitration. But what I've observed based on another empirical exercise that I published in the Oxford Handbook of International Arbitration is very intriguing continuities between the two practices. With almost the migration of leaders of commercial arbitration towards investment arbitration. I focused on the case of ICSID because the data is available. And once again, research is constrained and limited by the amount of data you can get. And ICSID is, of course, a great place to do research because data is available online, which is even more feasible and convenient. But you see in the 1970s, this early generation of leading arbitrators at the ICC, and I showed that table earlier, you see at least 3 or 4 of them already being actors of ICSID arbitration in the 1970s. You see Goldman being an arbitrator at ICSID in the 1970s, even though he was not a public international lawyer. He knew hardly anything about investment law. I mean, no one did, in fact, at the time. He was more of a commercial expert. You see André Panchaud, the Swiss arbitrator. You see also Gunnar Lagergren, who was also in that table. And so you see a migration from commercial arbitration and investment arbitration. And as you move forward, you see really a cross-fertilization between the two fields. You see that the two fields are not completely autonomous from each other, and that in fact they are quite unified, which is surprising, which is quite intriguing.
It is, I think, and that's why it's important to look at the data like you do, because my own assumption based on my personal professional experience was the opposite, was that investor-state arbitration was more and more moving towards a specialized field of practice. And I say that because I spent the bulk of my career in Europe, in London, and a bit of time in France, doing a mix of commercial arbitration and investor-state. And then 7 years ago, when I moved to DC, I moved into a separate arbitration community with different players who focus almost exclusively on investor-state arbitration. And one of the things that I thought was really interesting when I started to go to conferences locally in Washington, DC, was the fact that there seems to be a disconnect between the expectations of investor state practitioners in DC when it comes to certain procedural issues with the expectations of general commercial arbitration practitioners in terms of the what is best practice in terms of the length of proceedings and things like that. And talking of judicialization, I think investor state is even more formal now than commercial arbitration. So I would have assumed, that you had these different centers that were like or communities that were drifting away from each other. And that ties in nicely with a question that we had or comments that we had as we were organizing this webinar. One of my former colleagues, James Clancy, who was the registrar of the London Court of International Arbitration, was now really very much back into the world of shipping maritime arbitration. He has a leading role at the LMAA. James Clancy was criticizing or teasing us, Queen Mary and me in particular, for organizing this and calling this, the sociology and history of arbitration, when we should have said it was ICC arbitration, because arbitration is more than just ICC or LCIA arbitration. But a big point of tension here is whether or not there has been a drifting of these communities, whereby today in shipping maritime arbitration, people would do LMAA arbitration, in particular arbitrators. You have individuals who are simply not the same individuals as those who get appointed in ICC, LCIA, AAA, ICDR cases. Law firms that are different, and therefore, communities that simply have different not necessarily values, but expectations as to what best practices are. And that was my assumption. But James Clancy feels very strongly that this is wrong, and that in fact there is a single international arbitration community.
I think James is right. I think it's an oversimplification of speaking of international arbitration in the singular. Well, we did it for the purposes of this presentation, but we insisted on the fact that it is in fact rooted in a certain data set. I think your comment as to the professionalization of investment arbitration and the fact that it's growing more autonomous is an interesting thing to hear from a practitioner like you. I mean, my study was done almost 10 years ago, so it would be interesting to update it and to see how these planets may have gone further apart from each other. Yeah.
Mikael, if we have time, maybe a follow-up question. I know you focused a lot on the modern history of arbitration, and in particular, from the second half of the 19th century onwards. But have you been able to go back a bit further in time in terms of the use of arbitration and its historical evolution? Is that something you're doing now? Perhaps.
So I don't really have time to do it now, but it is absolutely fascinating. I agree. I mentioned earlier the legal historian and academic Derek Roebuck, and his history of arbitration begins in ancient Greece and Rome, and then covers England all the way up to the early 19th century. So some people have really tried to explore the ancient history of international arbitration. And I think this history is quite fascinating, but when it comes to the construction of the modern regime of international arbitration, I think the late 18th century and 19th century is a critical period that really provides key insights into the modern history of the field. And this is why I mentioned trade associations at the beginning of my presentation. We could also discuss the Great Alabama Arbitration of 1872, which provided key procedural innovations in the international arbitration field. And so I think we have to start somewhere when we explore the history of arbitration. And my position was to really start in the late 18th century and the 19th century. But there is, of course, a history of arbitration that could go even farther back in time.
And I think we're going to have more, the access to the sources will become a bit easier with technology, but you always have a double limitation when you want to do, as a lawyer, research into the ancient history of law. One, of course, is a methodological one, the fact that as lawyers, we are not trained as like historians are, and so there's a methodological limitation. Unless you train as a historian, you're likely to to make mistakes when you look at isolated sources. And the second one is simply access to the language. Ancient Greek and Latin, unfortunately, is not exactly something I master, but that's where technology is going to become more and more important and interesting with AI enhanced machine translation. I think some progress is being made, and it's going to become increasingly easy for legal scholars and individuals like me who don't speak or don't read ancient Greek and Latin to go back and actually look at the sources and do that research in international arbitration and other fields. So I'm really excited about what the future is going to bring. I had a last question, but in the interest of time, I've answered it myself. I wanted to ask you, Florian and Mikael, about suggestions of books and articles to continue to learn about these evolutions of arbitration. I've posted them in the chat function of this Zoom, so the attendees can access the suggested books and articles that you propose. And I think it covers it for me. Well, thank you very much, Mikael and Florian. I think that takes us to the end of this seminar. I certainly learned a lot, and I suspect our attendees did as well. So thank you so much for the work that you put into preparing this seminar and for the interesting research that's underlying this seminar as well. We're very grateful, and we hope to be able to continue this conversation, perhaps in on another conference some other time or in another forum. But I thought it was very, very interesting. Thank you.
Thank you so much, me. The pleasure was all ours. Have a nice day, everyone.